Ladies and gentlemen, welcome to the video channel of the Ludwig Boltzmann Institute of Fundamental and Human Rights in Vienna and the University of Vienna. Today, we mark the 6th EU Day Against Impunity. Initiated in 2016, this annual day is intended to raise awareness of the most heinous crimes of genocide, crimes against humanity, and war crimes. The day reminds us that these crimes belonging to the international core crimes continue to be committed and that the perpetrators quite often remain unpunished. The EU and its member states have committed themselves to collective action and cooperation to end impunity. Many states have enacted or adapted criminal laws to prosecute international crimes, even on the basis of universal jurisdiction. The commission of these crimes is directed against the international community as a whole, and the international community has taken action. In 1998, it established the International Criminal Court by the Rome Statute entering into force in 2002. The International Criminal Court is the only permanent court on the international level having jurisdiction over these crimes and therefore an important instrument to end impunity. I am very grateful that the recently elected president of the ICC, His Excellency Judge Piotr Hofmański, accepted our invitation for an interview on the occasion of the Day Against Impunity. Excellency, if I may start with my first question. You are a professor, you are the author of plenty of books and articles. You are an expert of several committees of the Council of Europe. However, in 1994, you also started working as a judge in criminal law. And I would like to ask, what have been your personal motives behind the decision not to confine yourself to academia, but also to work as a practitioner?
Well, the Polish system fortunately allows to combine academic work with the judicial service. It came as no surprise to anyone that immediately after the political breakthrough in the early 90s, the judiciary faced the difficult task of adjusting to the new rules, in particular to the rule of law unknown to the communist system at all. It was indeed a very difficult task. So having studied the functioning of the democratic systems of criminal procedure and criminal law before, I decided to support my colleagues adjudicating criminal cases. In retrospect, I assess the decision very positively. On the one hand, my academic knowledge turned out to be useful, especially in the Polish Supreme Court, where I have served for nearly 20 years. On the other hand, the experience with the judiciary had a positive impact on my teaching, as I was able just to show students, let's say, the criminal law in action.
Thank you very much. You have been recently elected president of the ICC, serving as a judge at the court since 2015. Following your election, you noted that the court is currently facing many challenges. What are, to your understanding, the biggest challenges the court is facing right now? And do you see a chance for these challenges to become overcome during your term in office?
Yes, there are, of course, many challenges facing the court. Part of them have been already overcome. Others are still before us. We can identify several distinct areas or types of challenges. Hostility from some states towards the ICC due to the court's activities. The US sanction imposed by the Trump administration are the most drastic example. The hostility is inevitable to some extent. Some will always be unhappy with the court's action. But states parties must mount a strong political support for the ICC all the times. Much support did came from forward in the last 2 years, but it could be more, I think. Many states truly spoke up forcefully, others remained quite silent. The other big challenge is certainly the state cooperation, especially as far as the arrest is concerned, particularly in the situation referred by the United Nations Security Council. I think it's really frustrating that the UN Security Council refers the situation to the prosecutor, but then does not follow up to ensure that the countries in question respect their obligations. Not many would argue against the idea and purpose of the ICC, and therefore I think that the most important will be to demonstrate the court's practical worth in a world of many competing priorities and changing international landscape. But of course, the mandate of the ICC is compelling. But can the court demonstrate to the international community that it meets the high expectation that were placed in it when it was created? We need to continue improvement and self-evaluation, and this is crucial. We have now the big review process carried out with very high, massive expectation of all stakeholders.
You mentioned the mandate of the International Criminal Court, which is to end impunity. Its jurisdiction is confined to the most heinous crimes under international law, under international criminal law. Is it possible, from the perspective of a practitioner and the president of the court, to say that one of the crimes, be it genocide, crimes against humanity, or war crimes, is more challenging when it comes to the prosecution?
First of all, we should not promote the idea that there is any kind of hierarchy among the core crimes under the ICC jurisdiction. Genocide, war crimes, and crimes against humanity all have their particular challenges from the practitioner's perspective because of chapeau elements most often linked to dolus specialis. I would say, in case of genocide, you must prove special intent. In case of crime against humanity, you must prove a widespread or systematic attack pursuant to a government or organizational policy and knowledge of the attack. In case of war crimes, you must prove that there was an armed conflict and that the crime was connected to it. The crime of aggression is new to us, and we probably come with its own set of challenges that we are yet to discover in praxis. No way of knowing when the first case of crime of aggression might come to the ICC. No point in making any prediction. We have jurisdiction since 2018, but only in respect of the 41 states that have ratified the amendment. The Kampala Amendment has introduced a special mechanism triggering jurisdiction of the court in the crime of aggression, based on requirements that were extremely difficult to meet. It concerns in particular the determination whether or not there was an act of aggression. Under the Kampala amendments, both the UN Security Council and the court have a role to play in this regard. A big difference is, of course, that while the other Rome Statute crimes come with a lot of jurisprudence from the ad hoc tribunals and other courts, of course, the crime of aggression does not, which is also probably why it was more difficult for the state to reach agreement on it.
As you mentioned, the crime of aggression, I mean, this crime is linked to the prohibition of the use of force under the UN Charter, though more narrowly defined. And there is an ongoing debate in academia whether it actually makes sense to have the crime of aggression being introduced in the Rome Statute. What do you think? How likely is it, bearing in mind the sensitive political dimension of the crime of aggression, how likely is it for the court to play a major role in addressing aggression under international law?
To tell you the truth, I don't think it would be the case. But of course, it is up to the state parties, entirely in the hand of state parties, to decide what is the crime and what is not, and we will fulfill our mandate respectively. But I really don't think it is my task just to express the wish of the court to have a certain crime under the jurisdiction of the courts.
I see your point. Talking about the jurisdiction of the ICC, we have seen that the Special Tribunal for Lebanon was vested with the competence to judge the crime of terrorism. There is an ongoing debate whether terrorism can be seen as a transnational crime. And there have been debates, for instance, at the Kampala conference, whether terrorism should also be part of the ICC's jurisprudence and competence. Do you think that terrorism is sufficiently concrete, defined, and should it be within the jurisdiction of the ICC from your perspective, maybe not as the president, but as a professor and a criminal law practitioner? Do you think it could make sense to have terrorism as an international core crime under the jurisdiction of the ICC?
Yeah, my answer will be probably the same. It's again the question for the state parties to decide. The court, as the court, we try to not to speculate of such questions, and it's difficult just to wear only one hat, if you understand what I mean. Mm-hmm. On our doing our part of the job, of course, we will implement whatever mandate is given to the court. But for sure, adding any new crime to the statute would require a long and complex process of negotiation. But we need also be aware that although the terrorism is not a part of our jurisdiction, of course, some of elements of crime we have under the jurisdiction include also the behaviors with our nature terrorism.
Yeah, I see. It's only the question whether there should be a distinct crime of terrorism. But yeah, as you mentioned, that is the job for the state parties to decide. Talking about state parties, talking about nation state, in particular EU member states, we see that nation state increasingly initiate criminal proceedings against perpetrator also of international crimes, such as war crimes or crimes against humanity, in particular against foreign terrorist fighters. Bearing in mind the principle of subsidiarity and the idea that ending impunity is not only the task of the International Criminal Court, but also the task of domestic courts, do you welcome these initiatives by nation states? And what might be problematic from the perspective of the ICC with regard to these domestic proceedings to enforce international criminal law?
This is purely a positive development, and we absolutely welcome all new national efforts and proceedings be in accordance with the principle of the universality of the jurisdiction. It was never the idea in any way that ICC should have monopoly or even priority. On the contrary, the principle of the complementarity, as we call it, not the subsidiarity, means that it is the national jurisdiction that should in the first place investigate and prosecute atrocity crimes. ICC can only step in if they don't.
Yeah, you mentioned before problems concerning the referral of situations to the ICC, in particular by the United Nations Security Council. We also face the situation that due to veto there is no referral, even though there should be a referral to the understanding of many in the international community. What we have seen is that the United Nations, the General Assembly, but also the Human Rights Council have established investigative mechanisms to gather information and evidence, to prepare criminal files, to ensure that later proceedings could become successful. For instance, the MMM mechanism for Syria. From your perspective, what is the role these investigative mechanisms could play for holding people accountable, for fighting impunity? The ICC initiated a proceeding concerning Bangladesh and Myanmar. It's currently under investigation. What, in your understanding, could be the advantages, but also the challenges by these investigative mechanisms?
There's no question that the fight against the impunity is a complex of efforts that will require different mechanisms in different situations. As ICC president, my job is to ensure that the ICC does its job well, and I do not want to comment too much on decisions taken or avenues chosen by international community in other situations. I, of course, understand the political considerations are an obstacle to the unanimity of the permanent members of the United Nations Security Council, and therefore the situation of Syria and probably also North Korea remained outside of the jurisdiction of the court. Certainly, the ICC is not against any other accountability mechanisms. All real efforts toward accountability can complement each other. Cooperation on sharing of evidence mentioned by you would be a question primary for the ICC's Office of the Prosecutor. They cooperate with many international agencies and national authorities to share evidence and to work together against the impunity.
Well, the ICC is the most prominent court in criminal matters on the international level. However, we still have internationalized or hybrid courts also addressing crimes of an international dimension. From your perspective, would you say that these courts are a risk or pose a risk of fragmentation, or could they adequately complement the work of the ICC, bearing in mind the limits on its jurisdiction we just discussed? What is your perspective on these other courts? Are they competitors, or are they a useful complementation of your work?
I would say that the field will never be fully unified, but I don't see huge risk for over-fragmentation. According to the complementarity principle already mentioned, ICC was never meant to be the only court, or that it would control national courts, for example. Nevertheless, the Rome Statute has helped enormously to harmonize legislation on the atrocity crimes across the world. The majority of the 123 states have incorporated the Rome Statute crimes in the national legislation, although several dozens still have not, and we hope they will. But also some non-state parties have used the Rome Statute as the basis. The landscape of international criminal justice is always evolving. 20 years ago, the emphasis was on international or internationalized courts and tribunals. Today, the emphasis is more on national proceedings and the ICC, as well as some hybrid models or national institutions supported by the international community, such as in the Central African Republic, for example. Law will always develop organically to some extent. International criminal law is a fluid field that involves national and international jurisprudence, many actors, and of course also many courts.
Mr. President, you touched upon the question of evidence, and we can see that the relevance of digital evidence has increased before the International Criminal Court in domestic proceedings, for instance, the Verfalli case, where arrest warrants have been based on videotapes. We know domestic proceedings that relied on digital evidence. We know that in particular, user-generated evidence is of high importance. There is a strong involvement of NGO. So on the one hand, this new type, I will call it new type of digital evidence, partly supported by artificial intelligence, is of utmost importance to fight impunity. However, from a human rights perspective, there are some doubts that remain towards this type of evidence. If you think of fake videos, of manipulation, and so on. From your perspective, what will be the role of digital evidence to play in the future? And what are the most prominent risks from your perspective with regard to digital evidence?
Undoubtedly, the specificity of proceedings in cases concerning core international crimes requires the use of unconventional measures, including digital evidence. One needs to be aware of how wide the scope of investigation conducted by an ICC prosecutor is, under what difficult conditions their investigation are conducted, and how enormous costs are associated with it. There's also necessary to be aware to the risk to the safety of witnesses, which may be exposed when using their testimony in a traditional way, I mean by giving testimony directly in the courtroom. Bearing this in mind, it's necessary to agree to the use of techniques enabling video transmission in a greater extent, and sometimes also pre-recorded testimonies must be taken into account. And Reggie, the COVID-19 pandemic should also be included here. Obviously, it complicates the issue of balancing the level of protection of conflicted values. But we also have to be cautious and judicious when we introduce new working methods. The defendant's elementary procedural guarantees must be respected. The task of the prosecutors and courts is to find the right balance. But I understand that your question about digital evidence also concerns the admissibility of such unconventional evidence as telephone tapping, emails, WhatsApp messages, and others. This is a question for the jurisprudence of the court, which is not yet developed sufficiently. The only limitation resulting from the statute concerns the compliance of the methods of obtaining evidence with the statute itself and with the generally accepted standards of human rights protection. The field for interpretation is really very, very wide.
So if we think about the protection of witness, equality of arms, maybe this is an invitation to the state parties to amend existing laws and procedural codes. Excellency, as we mark the Day Against Impunity, my last question would be, what is your message for the EU Day Against Impunity?
The fight against impunity is a long and demanding struggle, which has no end point. We owe it to victims, we owe it to future generation, and we owe it to humanity itself to do our best to answer atrocities with the rule of law, with justice. And by doing so, hopefully provide redress to victims and help prevent future crimes. The European Union has been a wonderful supporter of the ICC, and we trust we can rely on the support in the future as well. Equally important for each country to address international crimes in their national laws and their national courts as well, wherever necessary. The fight against impunity is a joint effort of states, courts, civil societies, international and regional organizations, and many others across the world.
Mr. President, I would like to thank you for taking your time and becoming involved in this interview. Many, many thanks. We are honored to have you with us. Thanks a lot, and have a good day. And to the audience, stay informed, stay interested, and join the video channel and the newsletter of the Ludwig Boltzmann Institute of Fundamental and Human Rights. Thank you.
Thank you very much.